cases. Oh, there's Mr. Peoples. We've got him in. Well, that takes care of that issue. So gentlemen, welcome. I would like to first find out on the appellant side, how are you intending to divide your time?
Your Honor, good morning. Dave Smolker here on behalf of Murphy Auto. We have agreed with Mr. Woislaw that we will allocate the time as follows. Appellant Murphy will go for 15 minutes. Pacific Legal Foundation will then go for 10 minutes, and Murphy will reserve 5 minutes for rebuttal.
Very good. And Mr. Peoples, you of course will have 30 minutes in your response argument. We had already entered the order expanding the time to 30 minutes per side. And so as my math shows, they've divided it up to 30 minutes, so we should be good to go. With that, Mr. Smokler, will you be beginning the argument?
I will, Your Honor. Good morning, judges. May it please the court. My name is Dave Smolker. I'm with the Smolker Bartlett, Loeb, Hines, and Thompson firm. We are representing Murphy Auto in this appeal. The Pacific Legal Foundation has filed an amicus brief, and we've agreed on the time. I'm going to give the court a brief summary of what I believe to be the relevant facts here. Murphy sought to develop an auto dealership on its property. The property fronted on State Road 27 in Haines City, Florida. 27 is a major 6-lane high-speed north-south arterial roadway that is part of the state highway system. Access to and from the property is necessary to its development and use. And Murphy's property under Florida law and Florida statute enjoys what is known as an abutter's easement of access that is appurtenant to its real estate that allows it to access and ultimately use the state highway system. The DOT required that Murphy obtain a driveway connection and related drainage permits authorizing construction of acceleration and deceleration lanes that would facilitate accessing the driveways to its proposed auto dealership. The additional pavement that would have been laid down within the DOT's right-of-way added approximately 10% to the drainage that was already within this section of the DOT's roadway. And ultimately, the DOT required Murphy to mitigate this drainage impact by reconstructing at its sole expense the pre-existing State Road 27 median drainage collection system, and to also expand the related drainage pond, which the drainage ultimately flowed to. And as a practical matter, Murphy really had no choice but to acquiesce, because if they had refused to do so, then they would not have been able to ultimately complete and open up the auto dealership.
Did they propose an alternate methodology?
Yeah, the way it played out was originally the DOT required as mitigation for the drainage impacts that Murphy dedicate 12 feet of right-of-way and to reconstruct a drainage ditch to connect it to the pre-existing drainage pond. Murphy proposed an alternative form of mitigation, and although it's not in the record, they felt that the dedication of the 12 feet would have been disruptive of their development plans for the auto dealership. And so, as is typical in these kinds of situations, there's negotiation that goes on in order to figure out how to mitigate this particular impact. And the ultimate proposal was to handle it through the existing drainage system that DOT had, and to expand the pond, pre-existing pond, to handle that additional amount of runoff. As it turned out, the existing system was inadequate to be able to handle that additional runoff. And
that discovery was made. The
Yes,
discovery of the inadequacy of the FDOT pre-existing drainage system was in 2013.
I believe that's correct.
Because it's my understanding, I'm just trying to put it in context, because I think in 2007, Murphy proposed the swell enhancement type of arrangement, but the FDOT did not either they did not accept it or it just, the deal was tabled because of finances, and then it was resumed or renewed back in 2012. My question is just simply this: does the record bear out whether that passage of time has anything to do with the adequacy of the FDOT system? Was it deterioration, anything like that?
As an officer of the court, I can tell you it's not clear in the record, but there was an issue as to whether or not the drainage pond had actually been properly constructed in accordance with the approved permits. And although that issue is never really addressed by the lower court, it would have been an issue that would have been addressed by the drainage engineers. But the ultimate issue is that although they were only contributing additional 10% of drainage to the basin that was being served by the system, they were effectively required to reconstruct the entire system. It's kind of analogous to a situation where, you know, you're the last car on the roadway that causes the level of service to fall below the accepted level, and all of a sudden the entire burden of fixing the roadway is placed on a single individual. So Murphy is not saying that they don't have some responsibility for the cost, but not the entire cost.
But I think you have a unique situation because you're asked to improve FDOT's property, correct?
That's correct.
But then they have to change hats as property owner and put on the hat of the regulatory agency and tell you how to do it, right?
Well, that's DOT's argument, but we would contend that if you review the relevant rules and statutes, which we've cited in our briefs, that they are not acting in a proprietary capacity where they're putting on their property ownership hat. And unlike the trustees of the Internal Improvement Trust Fund, which is some case law that's cited for that distinction, here the public, and in particular Murphy, had a right to access and use that highway system. And DOT's authority wasn't to decide whether to enter into a lease to allow you to use the road system or anything like that. It was simply to regulate your access and use of that road to ensure that for the benefit of the public, that you had a safe and efficient highway. So this argument that they were wearing sort of their proprietary property owner hat really simply ignores the legal framework under which they were exercising their power.
Mr. Smoker, one question just from a factual standpoint. I'm not sure if the record addresses this, but was Murphy able to use the property without accessing this roadway?
The answer is, I think the record does reflect the fact that their only access to their property was to State Road 27. So they could not have used their property without having access to State Road 27.
And as part of that use, they had to get permitting approval from DOT as well as other entities. Is that right?
That is correct. From the DOT, they had to get two permits. The first was a driveway connection permit. And that driveway connection permit also required that they provide turn lanes for the property, and especially deceleration lanes, because if you can imagine that you've got a high-speed roadway and you've got to be able to have the cars that are going to turn in be able to get out of the main through lanes and decelerate. Otherwise, what you have is somebody decelerating almost to a stop in a right-hand through lane where you have cars going at high speed. So again, this was part of the driveway connection process, and that required pavement be laid down, and the pavement created additional impervious surface, which created 10% more additional runoff. So that then triggered the need for drainage.
To distill your argument in what I think is the simple terms or the simplest terms, am I understanding that your position is Murphy had to get permitting, DOT was the regulatory agency to permit or enter into the permitting process with your client, and your client's position is the conditions that they were imposing were part of that regulatory scheme, the permitting scheme. I mean, is that in a nutshell what your contention is?
Absolutely correct, Your Honor.
And the conditions that they wanted as far as drainage, there is, from what I recall of the record, there is expert testimony and there are contentions on each side saying the existing drainage ditch was adequate to cover the additional, well, it was adequate to cover the existing runoff, but DOT's position is your client's work was going to create more runoff than was going to be handled by the system. And if I, again, recall correctly, your client's position was, with some expert analysis behind it, that the existing drainage ditch or drainage system was already problematic and that the work your client was going to require was going to add to the problem.
I think that's a fair characterization, Your Honor. And I would add one other thing, which is the concept of under Nolan, Dolan, and Kuntz is that not that you can't be required to mitigate, it's only that you can only be required to mitigate proportionately to your impact. And here, the basic problem was that having to reconstruct the entire system to handle the pre-existing drainage and have 100% of that charged to Murphy was not proportionate to its impact.
Well, and that ultimately is a combination factual determination as well as a legal determination. But in terms of the position that the DOT says that they were simply a landowner, I guess I'm letting DOT know what my concern is, that if your client had the right to access Highway 27 and had to access it, they couldn't access their property and use it for commercial purposes otherwise. It does seem that invokes the regulatory aspects. And so I'm not certain how your client could have used the property otherwise, but I'll look forward to DOT's answer on that. Do you have anything that suggests how your client could have used the property?
That question is directed to me, Your Honor.
Yes.
The record.
You had to respond to DOT's position, which is we're simply acting in a proprietary interest. I'm trying to figure out, okay, what could your client have done? And is it your position your client had no choice but to access the roadway?
Yes, Your Honor, it is. That was the only roadway that our property fronted. Therefore, in order to use the property at all, we would have had to have gotten approval from the DOT for a driveway connection permit. And that then led to the turn lanes, which led to the pavement, which led to the drainage permit, which led to the reconstruction.
Give me, I guess this is what I was trying to drive at, and I didn't articulate it very well. Can you give me an example of when, in your view, DOT would be acting purely in a proprietary manner?
Let's say that the DOT owns a office building. I'm not sure that they do, but let's just assume that they do. And I want to lease some space in that. I don't have a right, pre-existing right to lease that space. I have to sit down in an arm's length negotiation and see if I can get the DOT to agree to terms of a lease. That's entirely different than the situation we have here, where you don't have equal bargaining power. Two, you have to get the DOT's approval in order to use your property. The government is regulating what you're able to do with your property as a condition of giving you that permit by saying, look, you're going to have to mitigate your impact on our drainage system. And in order to do that, you're going to have to make improvements to the public land. And I think that the unconstitutional conditions doctrine, and I would cite to the town of Flower Mound case, which we've cited in our brief, makes it crystal clear, I think it's our reply brief, that it doesn't matter whether you're being required to make improvements to your own property or being required to pay a fee or being required to spend money to improve the public's property. If as a condition of development approval, you have to mitigate your impacts, then that mitigation has to be proportionate to the impact. It can't be disproportionate. And that's essentially what we're arguing here is that this requirement was not proportionate. And ultimately, you know, I think it's worth going back to sort of the genesis of this case. The DOT argued in their affirmative defenses that Nolan, Dolan, and Kuntz simply didn't apply because they were the requirement and the demand, they characterized it as, to pay money was exercised pursuant to their proprietary powers. And so that was a threshold issue. It had to be addressed as a matter of law by the trial court before we would be proceeding with the case. Summary judgment motions were filed. The judge agreed with DOT, and that's why we're here.
And in terms of the monetary aspect, I think DOT has conceded that can be an extraction, correct?
Yes, and I would point out that they do concede, DOT does concede, I believe it's at pages 17 and 18 of their brief, that the unconstitutional conditions doctrine does apply to the exercise of proprietary functions. I mean, if we're going to take a really narrow view of the court's order and the affirmative defense, I think they've essentially conceded to our position, but they do raise, I would say, a nuanced argument that, well, it doesn't really apply in the special situation of a land use exaction because the property wasn't burdened. Murphy's property wasn't technically burdened. So I think that they've, in a way, kind of shifted the focus of their argument away from what the judge actually ruled to a slightly different argument. And, you know, we've addressed it, and I think it can be fairly addressed.
Very good, Mr. Smokler. Mr. Voislaw, you have 10 minutes for your argument.
Yes, Your Honor. Thank you, and may it please the court. Daniel Voislaw, I represent Pacific Legal Foundation as amicus curiae in this matter. And I'd like to clarify our position right up front, which is not that we're not taking a position essentially on whether these conditions imposed on the permits were either a reasonable and lawful request or condition on the one hand, or an unconstitutional extortion and exaction on the other. Our problem is that the lower court failed to apply the proper test for determining which one of those this was, which is the rough proportionality and nexus test from Nolan, Dolan, and Kuntz. There are two main points that I'd like to address here today with you, Your Honors. On this topic. The first is that there really is no proprietary exception to the unconstitutional conditions doctrine. To contend that there is one is, in our position, a misunderstanding of the way that this doctrine works. And the second is that this case is very much in line with Kuntz versus St. John's River Water Management District, in that the conditions here and there were to mitigate the effects of development. The permit there and here was a necessary precondition to the development and use of land. Here we have actually two property interests, the connection to the roadway, as well as the development and use of the land. And third, that the government sought a dedication of land and the improvement of public lands, both in Kuntz and here in Murphy-Otto. So first, I'd like to address the proprietary exception and the way that the unconstitutional conditions doctrine works. The focus of the unconstitutional conditions doctrine is the condition itself. It's not the benefit sought. And the court has been very clear on this going back about a century into its first case law considering the unconstitutional conditions doctrine. And it stated this in Kuntz, where it says that it's not the entitlement to the underlying benefit that matters, it's the condition that's imposed and whether that condition burdens the exercise of a constitutional right, which here, the right to connect to the roadway and make productive use of the land here is certainly one such right, and not to have the property taken, that is the 12-foot right-of-way, or the improvement of public lands that triggers the unconstitutional conditions doctrine. The court has been very clear on the fact that the greater power to withhold the benefit does not include the lesser power to condition it on a condition that burdens a constitutional right. And so there's a two-part test in the broader unconstitutional conditions doctrine. The first step is to ask, could the government do this directly? So outside of the transaction here, could the Florida Department of Transportation have said, give us this 12-foot right-of-way or improve these public lands? And the answer to that has to be unequivocally no. It couldn't simply order Murphy-Otto to do that.
They have been trying to read.
And so then we move into the second prong of the test, which is, could the government do this indirectly through a permitting process? And in the context where you have a permitting authority standing between a landowner and their exercise of real property rights, which we have two triggered here, that triggers Nolan, Dolan, and Kuntz scrutiny. Nolan, Dolan, and Kuntz is a test that has been developed specifically for this type of a scenario, where you have a government permitting authority essentially holding all the cards in between a landowner and their right to use their property. It's uniquely positioned to ask the question of whether there is a nexus between what the government's asking for and whether it's roughly proportionate to the perceived negative externalities of the use of the land. So does the increased impervious surface of the acceleration, deceleration turn lanes that Murphy had to build, does the increased drainage from that impervious surface, is that proportionate to the work that was asked to be done or the dedication that was asked from Murphy? And this was actually exactly one of the topics that was considered in Dolan versus City of Tigard, where the developer there increased impervious surface by building a parking lot. And that was one of the reasons for the condition imposed in Dolan versus City of Tigard of the dedication of the lands. Similarly, in Kuntz versus St. Johns River Water Management District, we had a development that was going to cause some externalities to conservation lands or to wetlands. And the developer there was asked to mitigate those externalities by either dedicating some of their land or alternatively doing improvements on public lands, just like is the case here. So I'd next like to address the implications of recognizing a proprietary exception. There really should not be any distinction between the government acting as a landowner or a regulator here, because the focus, as I've mentioned previously, is on the condition.
Let me ask one question, because I asked Mr. Smolker for an example where the proprietary or ownership interest of DOT might fall outside of this context. And he gave the example of a landlord who is negotiating with a prospective tenant over leasing space. Do you acknowledge that the unconstitutional conditions doctrine would not apply to that scenario?
My very lawyerly answer, Your Honor, would be that it depends. And what it depends on is what the condition is. And so what Mr. Smolker proffered to the court was some sort of a rental agreement. So that would be, payment of funds in order to rent the land. But if the government said, oh, we'll only give you this lease if you give us this dedication of land or improve public lands, then you have the condition burdening a property right, which is receiving compensation for the land that the government is asking you to give up. And so
why would that not be purely a negotiating point between two parties who are not dependent on one another for a specific exercise of governmental authority? For example, in this case, we have a permitting process that's being invoked and being impacted. But in a landlord situation, it does seem to me that is purely a proprietary negotiated strategy, as opposed to government using its powers to defeat someone from exercising a right they otherwise have. There is no right to rent space from a governmental entity, at least not in the context of this kind of discussion, is there?
No, Your Honor, but to return to the way that the unconstitutional conditions doctrine works, the emphasis is on the condition itself. Now here, if we step outside of that condition, this case is quite different from that you've illustrated, and that so
there is a possibility that there would be a proprietary interest that would not necessarily invoke the unconstitutional conditions doctrine.
Your Honor, that's not the position that we take here.
Well, he's asking you to answer a question, sir, and I really wish you would answer it, because if a private person wants to rent government space and enters into a lease with the government, are you always saying that's coercive and improper? No, well, then you agree. Then you would agree that there are certain situations, you would agree with Judge Silberman, that there are proprietary claims a government agency can make, correct?
Yes, Your Honor, absolutely.
Okay, thank you. Go ahead.
Yes, and that's certainly distinguishable from this case where we have impact mitigation fees and requests for the dedication of land, as opposed to merely if the government had asked for a processing fee. That's not something that burdens the right to receive compensation for land that the government is seeking through a permitting or a conditioning or a negotiation process. And the distinction is that when you have the government that's on the other side of the table, there's an asymmetric bargaining scenario. But to go back to this proprietary exception and the implications that it would have in the context of land use permitting. Essentially, if there was such an exception, the government could essentially backdoor conditions that would not pass constitutional muster if they were attached to what is labeled as the land development permit to connection permits that are likewise necessary to make any real use of the land, such as sewer connection permits or water utility connection permits, or in this scenario, a roadway connection permit. And so there's a real concern that just talking about how the permit is labeled rather than its functional obstruction to the exercise of a property right is quite concerning. The condition here is, and we don't necessarily disagree entirely with the way that the government asserts that this condition is defined, but it depends on the level of abstraction that you use. So the government defines this condition in their brief essentially as the mitigation of impacts on public property via the drainage from the proposed project. At that level of abstraction, it's essentially the same condition that was in Dolan versus City of Tigard and Kuntz versus St. Johns River Water Management District. At a lower level of abstraction, it's clearer that the dedication of the property and the improvement of the drainage system are very similar to what happened in Kuntz and it is similar here. I'd like to conclude, Your Honor, by cutting to the heart of this case, which the heart of this case is essentially, did the department impose reasonable conditions, asking Murphy to mitigate for their negative effects of increased drainage, or were these demands extortionate exactions under the unconstitutional condition? The answer to that question is Nolan, Dolan, and Kuntz. So we recommend that this court remand to the lower court to hear evidence and arguments on rough proportionality and nexus. Thank you.
Thank you, Mr. Westlaw. Mr. Peoples.
Good morning. May it please the court, Mark Peoples for the Florida Department of Transportation. Mr. Smolker conceded, and after a while, Mr. Westlaw conceded that there is no pre-existing right to lease government property. Similarly, there is no pre-existing right to use the department's drainage system in Highway 27.
But they have the right to use the roadway.
They have the right to use, well, yes, and they have the right to use the roadway. And to answer your question, Mr. Judge Silverman, they do have the right to access the roadway. We concede that. But the drainage permit was not the same as the driveway permit. They're two different things.
They needed both permits, is that correct?
They did.
And Department of Transportation.
And the record reflects that.
Hang on. The Department of Transportation controls, at least in part, the issuance of both those permits, correct?
Yes.
Okay.
Yes. Murphy conceded below that the requirement to expand the culvert was in relation to the drainage permit, not the driveway permit. So I don't know if that...
They had to get both.
They did have to get both, but I don't know if that answers your question. I think that the concern that you raised with Mr. Smolker was that their property couldn't be accessed absent the driveway permit. We don't dispute that, but the drainage permit is... But
in order to get the driveway permit, DOT had to impose certain conditions because it believed there was going to be additional runoff created by virtue of the driveway permit being issued no matter what. Isn't that correct?
Well, no, the driveway permit and the drainage permit are two different things. The driveway permit allowed for the...
Let me ask it this way. Could the driveway permit have been issued without addressing the concerns of DOT in terms of issuing a drainage permit as well?
I hope this answers your question. Once the extra half-acre asphalt was laid for the
But in fact, let me maybe make it a little clearer.
Okay.
Is there any way that the driveway permit could have been issued standing alone without regard to the drainage impact?
Without regard to the drainage impact. But by rule, if
I think the answer is no. I think the answer is.
I think the answer is no. By rule, I do want to clarify one thing though. There's been some focus on the drainage permit being a regulatory as opposed to proprietary power. And I think I direct the court's attention to the rule governing drainage permits. It's Florida Administrative Code Rule 1486.003. And it states that a drainage connection permit is required for all improvements on an adjacent property.
So the answer to my question is they are interrelated.
They are interrelated. However, to the extent that a drainage permit is regulatory, it goes on to say, to the extent the plan, that is the stormwater management plan proposed by the developer, to the extent the stormwater management plan relies on the use of any department facilities, such use must have department approval. So
which seems to, on its face, invoke the governmental discretionary authority in permitting as to what's required, how it's going to be impacted, how the land will be impacted, and how you're going to condition issuance of the permit, correct?
Again, I draw a distinction between a regulatory authority to regulate stormwater runoff and ensure that the stormwater runoff doesn't adversely affect the roadway from if the developer proposes to use the department's drainage facilities, they're not required to use the department's drainage facilities. The amicus brief goes into some speculation about, well, what would happen if a government required the use of a drainage facility? The department had no such requirement here. This was Murphy's idea to use the department's drainage facility. They weren't required to do that. They wanted to do that, presumably because it was cheaper and easier to use the department's drainage facility than it would have been to take care of their stormwater on their own.
Why did they need a permit to use your facilities then?
They need a permit. It's our facility. If
okay,
they have no
who's the only game in town that regulates permits?
We issue stormwater management permits.
Right.
Yes.
You own that property, but you also have to approve the permit, specify the certain conditions that must be met, and make sure that they're satisfied, right?
Yes.
Okay, so how's that not regulatory?
Because there's no requirement to use our drainage facilities. There is a requirement to ensure that the drainage doesn't negatively impact the highway system. But if part of your plan to make sure to come within that regulatory regime to make sure that the roadway system isn't negatively impacted, if part of your plan is to use our property, is to use our drainage facilities, that's when our proprietary authority takes over. That's when we act as a property owner, not as a regulator.
But you use the code in forming the permit requirements and in enforcing the permit, as opposed to an arm's length transaction.
That's correct.
That seems regulatory to me.
Okay. Perhaps we can answer it this way. There is a distinction that I don't think was developed when my counterparts were arguing between the St. John's Water Management District telling Mr. Kuntz, you may not develop your own property unless you agree to fund off-site mitigation, versus the department telling Murphy, you may not use our property unless you agree to mitigate.
But if he doesn't use your property, he can't use his property. He can't access it, could he? I mean, the record doesn't show that he had alternative access.
Access and drainage are different things.
But he can't access it without there being appropriate mechanisms to deal with what your department was appropriately concerned about, which is it's going to create runoff. Okay. So that's why the two seem to go hand in hand in a regulatory scheme or a regulatory manner.
The department did not require Murphy to use our drainage system.
There was an alternative available. They could have gone under the road. They didn't have to use your property, but by using your property, it saved them money. So, I mean, the question becomes is, yes, you have a sovereign immunity right to use your property any way you want. And you could have said, no, you can't use our property. So the question becomes is once you say, yes, you can use our property, but here's the only way you can do it, aren't you then required to act in good faith? Once you say yes, don't you have to give a good faith disposition? And that requires the use of the regulatory process as your poll star.
Well, I certainly agree that the department is required to act in good faith.
Well, you said yes to the drainage request, correct? You said yes, you can use our property for your drainage.
Yes. We said yes, so long as you can demonstrate that there's no adverse impact. They couldn't demonstrate that. And so in negotiations, as Mr. Smoker said,
isn't that a question of fact? In other words, you got off on summary judgment. He's saying, hey, we want to test this. We want to do our proportionality. We think they're overreaching. We think they're abusing their authority. And how is that ripe for a summary judgment?
It's ripe for summary judgment if the trial court is correct and if the department is correct that there is a distinction between holding development of your own property hostage to a permitting process versus agreeing or denying access to the department's property.
And why should there be that distinction when it comes to a government entity? Why should they be able to just say, you can't use our property under any circumstances? Because they traditionally do allow it, and most people don't dispute the conditions that are attached to the permits.
I think that a distinction I would draw is that, well, take the Nolans, for example. The Nolans asked the California Coastal Commission for permission to develop their own property. They had a small bungalow, they wanted to expand it. California said, we will grant you a building permit for your own property, conditioned upon you agreeing to dedicate an easement for pedestrian traffic to the beach. The Nolans couldn't very well shop that deal around to Oregon or Nevada and say, I don't like the deal that California gave. Can you give me a better permit to develop my own property? California was the only game in town. Here, again, Murphy asked to use our property.
Let me just for edification, let me ask this question. If Murphy decided to construct a drainage system on their own property, they still needed a permit, correct?
Yes.
From you?
Yes.
Okay. Well, they decided to use your land that's across the street.
They asked
and they needed a permit for that.
They needed our approval.
Okay.
Yes.
So in either scenario, you're the regulatory authority.
If they can find the right of way, if they were able to confine the drainage to their own property, yes, we would act as a regulator to ensure.
Well, sure you would, because if you disagreed with their system, you might even make them expand it, whereby they would lose commercial space. They wouldn't be able to put all of the vehicles or as many vehicles as they wanted if you required them to expand it.
And obviously, we're speculating and dealing with hypotheticals here, but yes.
So they decided to do it on your land.
Right, because presumably it was better and cheaper and easier.
And the gravamen of their complaint is, by virtue of doing it on your land, you required them to do more than what was necessary.
That would be the Nolan-Dolan rough proportionality substantial nexus test.
Okay.
And you
And
argue that
Why
doesn't
do you have
apply.
why do you have sovereign immunity, even if it's on your property and you're the sole regulatory agency? They want to use your property, but you tell them you've got to go beyond what you want to do. We want you to do this, and they consider that to be excessive. You're sovereignly immune from that? Making them pay $1 million to build an elaborate drainage system as opposed to the swell system that they wanted to do, but your company rejected.
I'm not quite sure that I would agree with the elaborate. Basically, they expanded 900 linear feet of culvert pipe to make sure that that it drained adequately.
Did it go under 27?
Yes.
Okay.
Yes.
Let me ask one follow-up question to that, Mr. Peoples. As I understand what you just said, and when I read the record, there was talk about the loss of parking spaces if they try to build a system on their own property. Mm-hmm. Either way, your department would have been involved in regulating the system on their property or on your land to make certain that the drainage was adequate, and your department would have imposed whatever restrictions were necessary or conditions were necessary to assure that the roadway would not be adversely impacted under either scenario.
I want to make sure I understand. The question is, had they opted to confine the drainage to their own property, would the department have regulated that?
Yes.
Yes, in conjunction with the water management district in the city, right. Yes.
But the department, I'm not sure why you had the explanation at the beginning of your answer. It seems like no matter what was going to happen on Murphy's property, you would regulate it to make certain it didn't affect the roadway. You might impose certain conditions to make certain it didn't affect the roadway. And if it turned out they wanted to use the roadway drainage system that was adjacent to it, which they did, you again would have regulated it. So is there any circumstance in which you would have said, go ahead and do what you want, as long as we know and you can prove that there's not going to be overflow to the roadway, we don't care what you do? Sure. Did that discussion ever come about? Was there ever any talk where your department said, you're able to do it on your own, we'll give you the permit, what's the plan? The record doesn't reflect that conversation ever took place. Presumably because, as I've been saying, it wouldn't have been economically feasible for a variety of reasons. Perhaps Judge Sleet is right, that they would have lost parking spaces, and once the department and Murphy start talking about the use of the drainage system adjacent to the department's roadway, doesn't the department at that point engage in regulatory practices as far as what the department's going to require? And I think the answer is yes. I think I still believe that if the proposal, and this was Murphy's proposal, is to use the department's property, the department's drainage system, the department acting as a property owner has rights that it may not have as a regulator. Once the department enters into negotiations for the use of its property and it starts imposing conditions in order to protect the roadway, it seems to me that it is acting as a regulator. So tell me why I'm wrong. For the same reasons that if the department wanted to lease an office space but said no allowed parties, or make sure that you're not flooding the office.
Can I ask you a question?
Yes. You're
trying to make a distinction that DOT is legally able to wear two hats, right? One proprietor, one state agency. And it seems to me the proprietor hat comes under the big hat. You're always going to be a state agency. You're not always going to be a proprietor. And to try and say this gives you a unique right, the same as a private individual, seems to be a stretch to me, because you're always going to be a state agency. How am I wrong on that one?
Well,
DOT.
Yes, we're always a state agency. That's true, but we're not always going to own the property.
So you're saying the opposite of me.
Yes, we would. The hypothetical that we've been talking about is, what if they confine the drainage to their property? We would be acting solely as a regulator, not as a property owner.
All right. Well, I mean, when you agreed that DOT had a duty to negotiate in good faith, it seems to me they're wearing two hats with one bigger hat as the umbrella, the DOT hat. I don't see how they can say we have private property rights the same as a landlord. It might be similar, but it comes under the DOT hat. That's why I'm getting hung up on your argument.
By statute, we own the right of way. I don't think that there's any dispute over that. Does that answer your question?
Right. And your point is there's no private right to use your right of way unless they can do it in good faith. And there's no reason that you told me before, DOT, if they can't show that there's any unfair advantage or any unfair harm to the property, you'll generally give them the permit.
If
there's no detriment to the request.
Yes, if they show that there's no adverse impact, then the permit will issue, yes.
All right.
But isn't the distinction with the lease issue that is an arm's length negotiation for use of a building or a part of a building that they don't necessarily have to have, and that doesn't impact anything else. Here we have property that they own adjacent to the roadway, and they have no choice but to deal with the department for both drainage and the driveway and the access. So
they certainly had a choice as to whether or not they had to use our drainage facilities.
But they had, no matter what they did as far as drainage, the department would have had to exercise its permitting authority, whether they did it on their part of the property or on the highway, right? They could not avoid the department. Whereas in the leasing situation, they could avoid the department by not engaging in negotiating for that building.
They could avoid the department's right as a property owner. They couldn't avoid the department's right as a regulator. Does that answer your question?
It does.
Okay.
It does.
Yes. But when the department when that condition was agreed upon, the department was acting, in Judge Valenti's terminology, was wearing its property owner hat.
But when it imposes the conditions and it is conditioning issuance of the permit on those conditions, then it is wearing its regulatory hat.
Not when they're requesting to use our property.
Well, when you say you can use our property, you're, for purposes of this argument, you're talking about, can you use our property? We're the owner, what do you want? And they say, here's what we need, here's why we need it. We want to be able to use our commercial property. And you say, we're willing to talk to you about it. And they say, okay, well, let's talk about it. And you say, well, if you want to use our property, then you can only do so with these conditions. And you as the owner have the right to impose certain conditions. But if you don't meet those conditions, we're not giving you a permit, which means you can't use your property, right? And they can't
use the department's property, not
no, they can't use their own property. They cannot, you cannot give them the access to their property without also giving them the drainage permit. I mean, that's what you said earlier, is that they have to get both permits.
Yes, they would. So they would have to get both. They would have to get both permits.
The regulatory hat that the department has to wear comes into play at some point in time.
I'm sorry, could you repeat that? I missed the first part.
The department has to put on the regulatory hat at some point in time during these discussions. Is there any way to say, no, we don't have to?
That would be acting solely as a property owner as opposed to wearing both hats?
Right.
I don't think so.
Okay, so once it puts on its regulatory hat, doesn't that whole line of cases come into play? Okay, now you're regulating. And so are you imposing?
No, no. And the reason is because the special application of Noen, Doen, and Kuntz applies in land use permitting. We aren't regulating the development of their property. They could build this car dealership without the department say so. They didn't need department permission to do that. Unlike the Noens, unlike Doen, unlike Kuntz.
Well, then you're saying they didn't need any permits from the department. If you just said that, then it seems to me you're saying
developing versus developing their property versus the access to the property. They did need the department's permission to build that turn lane because it's in the department's right of way. And yes, the department can reasonably regulate access to and from. They have an abutters easement. Mr. Smoker's right about that. What they don't have is a right to use our drainage facility.
And then they also have to get your department's permitting for the drainage. That is going to happen no matter where the drainage goes. Wherever that flow goes, you're going to have to approve it.
Yes, but the conditions weren't imposed because the expansion of the culvert didn't depend on them retaining the drainage in their own property. It was because they wanted to use ours. They were going to burden our system. Our system was working fine. But
well, there's a factual dispute about that, correct?
Yes, and there is a factual dispute about that. Yes.
But just so you know, Mr. Peoples, I know we've beat this particular issue into the ground, and I don't want you to lose your time on anything else you want to address. You still have 5 minutes, but I just wanted to let you know.
I appreciate that. I'm here at the court's disposal, and it's obvious that the court has questions, and that's the reason I'm here, is to answer.
Well, I have a question then. If you want some more questions, I'll throw one at you.
Sure.
So DOT constructed the original drainage system in the median.
Yes.
And they, as a regulatory authority, constructed that system according to the code, correct?
Presumably.
Okay.
That's not
so
the record.
When Murphy decided to use your property, you basically gave them certain instructions on how it was supposed to be done. And they were told to enhance work that already had been done by a regulatory agency.
That's not quite right. The analysis of Murphy's engineer was that it would lead to extra runoff, which just stands to reason. But in building the turn lanes, not only did they lay an extra half acre of impervious asphalt, they also filled in a drainage ditch. And it was Murphy's engineer that found that 900 linear feet of culvert would need to be expanded to meet that high gradient line. This is all reflected in the brief, that high gradient line standard that the department's engineer refers to in his affidavit. So no, if the question is, did the department require, or did the department's analysis say expand the culvert? That came from Murphy. I refer Your Honor to the affidavit of the department's engineer, where he quotes the passage from Murphy's engineer's analysis. So I continue to believe, and I'm not sure that I've convinced the court of this, but I continue to believe that there is a fundamental distinction between the government. How did Mr. Woodruff put it? When a permitting authority stands between a landowner and the right to use property. The state of California stood between the Noens and the right to expand their bungalow on their property. the city of Tigard, Oregon stood between Mrs. Dolan and the right to expand her hardware store on her property. The St. John's Water Management District stood between Mr. Kuntz and his right to develop his wetland. The department did not stand between Murphy and his right to develop his property. The department did regulate, as it's supposed to under the statutes, did regulate access to that property. And once that access plan demonstrated that it would lead to increased runoff, did require Murphy to establish that there would be no adverse impacts to the highway drainage.
And you're saying the department is the sole arbiter of that question. If the department says adverse impacts can only be satisfied with X, that's the end of the inquiry as a matter of law because it's a proprietary interest. If the other side is saying, hey, that's overkill, we don't have to overcompensate our request, and you're saying you don't get that decision, you can't dispute that. And that's why the trial judge gave summary judgment in this case.
Well, I'm saying that unlike the Nowens, Doans, and Kuntz, if Murphy thought that the department's condition on the exercise of its rights as a property owner was excessive, and when I say it's, I mean the department's rights as a property owner.
Right,
When
because they own their own property you were regulating. And you're drawing a distinction. The department owns the property that they want to use.
Right, exactly.
That's
exactly.
a big distinction in your view.
In my mind, in my mind and in the trial court's mind, that's a critical distinction.
And that makes summary judgment unreviewable if your argument's correct. They win as a matter of law. We can't second guess that.
It makes unreviewable. I won't go that far, but it should be affirmed.
Okay, far enough.
And the reason why it should be affirmed is because unlike the Nowens, unlike Dolan, unlike Kuntz, who couldn't very well shop around their permit of their own land to Arizona or Portland or the South Florida Water Management District. If Murphy didn't like the conditions the department was imposing on the use of the department's property, Murphy could do something else to mitigate drainage.
And Mr. People, that brings us to the conclusion of the time for your argument. So thank you very much. And we will now hear from Mr. Smokler for his rebuttal.
Thank you, Your Honor. May it please the court. First of all, there is no evidence in the record of this case that Murphy had any alternative to deal with the increased drainage from the pavement within the right-of-way of DOT other than to make drainage improvements within the DOT's right-of-way. There were alternatives to doing that, but there was one of the alternatives was never that Murphy was going to handle this drainage on its property. And I want to make it clear, in terms of the development of Murphy's land, all of the drainage from the development of Murphy's land, as distinct from the DOT's right-of-way, was being handled on Murphy's property. They were not discharging drainage to the DOT. The triggering event for having to deal with drainage was the pavement in the DOT's right-of-way. And the only alternatives that were ever on the table were alternatives to either dedicate additional right-of-way and reconstruct a drainage ditch, or the alternative that Murphy and the DOT ultimately agreed to, which was to reconstruct the median collection drainage system and to expand the pond. So it's not, you can't say, based on the record in this case, that there's any evidence that Murphy had any choice but to deal with this in the DOT's right-of-way.
So let me ask you a question. Would we be looking at an inverse condemnation case if his position is correct? If his position is you can't use our property and we're the sole judge of that, then you're stuck with owning property you can never develop because of a DOT or government agency position. So was that therefore leave you with an inverse condemnation case?
Yes, and that
You
is
shouldn't have to pay tax on land and never be able to use it.
correct. That is exactly the claim that we brought. And I'd like to refer back to one of the comments that Mr. Wozniak made that I think is very telling, which is assume for the moment that the DOT was in the process of designing and engineering the 6 laning of SR 27. And Murphy came along at that point in time and said, we want to develop our auto dealership. We want access to your State Road 27. We want to coordinate with you with regard to the design of your roadway. Had the DOT said, oh, fine, in order to mitigate that 10% of additional drainage, you have to construct this drainage system for us so we can use it for all of the other drainage that's already going to need to be handled, everyone would agree that that would be a taking because it's not proportionate. So it makes no difference whether Murphy comes along before or after or at the same time. The fact of the matter is, as soon as the DOT conditioned this permit on constructing public improvements, spending money to construct public improvements, it necessarily implicated the unconstitutional conditions doctrine and required that we take the next step, which is to evaluate the essential nexus and rough proportionality issues. And so I think in this particular instance, the DOT's position was, hey, it's our property. We're acting in a proprietary capacity. Nolan and Dolan don't apply. Judge granted him summary judgment on that. That's the issue. And our contention is that the trial court erred on that point, that he should have taken the next step and evaluated the proportionality of requiring that Murphy essentially pay 100% of the cost of oversizing this system, even though it was only contributing 10% of the drainage that required.
Well, I mean, the alternative would have been for DOT to have made some sort of future planning based on future use while the land that Murphy developed was still vacant, but they're not required legally to do that. They can plan their road expansion based upon vacant land next door. So they didn't plan for this. Now, after the fact, we have to kind of retrofit development, which you can almost assume that development is coming at some point.
Yes, and I think that's a fair assessment of the situation. And I think that in the final analysis, had both parties been moving forward with the DOT with the 6 laning of SR 27 and Murphy at the same time with the development of its auto dealership, what would customarily happen in that situation is that you would enter into what's called an oversizing agreement. And that's where the developer actually constructs the public improvements and shares the cost based on its relative contribution to the need. Right. And that's typically how it would be done if both parties were moving forward at the same time.
But the corollary is if you had an existing business and DOT wanted to pave over and expand the road, they would have to provide all of the drainage for your business. They couldn't just flood you out.
That's correct.
And say, hey, you got to provide some more drainage here, buddy. It would be on DOT. So it's a matter of timing, a lot of this litigation, it seems to me.
Well, I think it is, but I think the principles are timeless.
Mr. Smoker, you're at the end of the time, but I want to ask one question to address something that Mr. Peoples had raised, that you could have, and I'm not sure that the record does provide information on this, but that if you could have handled all of the drainage on Murphy's property, then Murphy chose to negotiate with DOT because it would have been cheaper, let's say. Would the unconstitutional conditions doctrine come into play at that point? Or do you concede that at some point it doesn't come into play if your client voluntarily wants to use the drainage system that the highway has?
It always comes in. And the reason is that if it is a condition of development approval that requires improvements be made or dedications be made of private property for the benefit of the public, then the unconstitutional conditions doctrine is triggered.
So if your client had the ability to handle the drainage on its own property and the cost was double what it would take to do it on the DOT's property, your position is it doesn't matter that we could have done it on our own property. Once we start negotiating with them, then the doctrine comes into play. Is that your position?
The answer would be if we were only handling the additional 10% of drainage and we could have done it on our property, then we would have done it on our property.
Well, would have,
yes.
Could have, should have, but let's assume that you could have, for the sake of argument, if you could have, but your client elected not to because it preferred to use its space in another manner. So it says, yeah, we could do it for double the price on our own property and we lose some space. We'd rather use your highway system. Does the doctrine come into play?
I think it does in order to test.
No matter what, even if there was another alternative, once you negotiate or start negotiating with the department, then your view is the doctrine comes into play.
Yes, and let me explain why.
I've let you go over.
Yeah, had the DOT basically said, hey, deal with this drainage, the 10% on your own property and not ours, yeah, we would have evaluated that and we would have made a determination as to whether that would have been something that we would have wanted to do. But what ended up happening here was they asked us to handle more than just the 10%. All right, we had to handle an oversight of it all.
We understand that point. So unless there's any other questions from the panel, and if not, thank you both, or all three of you actually, for the arguments. Very interesting case. We are going to take a 10-minute break before we go on to the last case, which is Dieterle versus Jacobson. So we are in recess for 10 minutes.
Thank you, Your Honors.
Thank you, Your Honors.